Good morning, good afternoon, good evening, no matter what time it is, just know today is the day, just like every other day is the day that the Lord has made, and I will rejoice and be glad in it. As always, God is good and He is good all the time. All right, y'all. So today we get into a little trolling video, okay? A little trolling video amongst the California senator with the U.S. Supreme Court judge. But anyways, without further ado, we gonna get into the music first because you know we always gotta start it off with some motherfucking music. So let's go.
Yeah. Oh. Yeah. Wake them up. DJ Boat. Kobe Joe. Mama talk say they know they rush am. If not true love, no need to force am. Set my eyes on you, my life don't change. For real, my objective, I want your heart. I see how you move your body, girl. Olowo laye mo, that's why I'm working, girl. See my baby vibe, I make you no go away. God bless the day, baby, say you come my way. Give me love, give me dance, oh, give me life. Skibby that, make I die for your love. Give me touch, make I fall on up. Adore you. Give me love, give me that, make I dance, give me love. Make I feel your body, give me love. Give me that, make I dance, give me love. Adore you. Give me your love, my baby, adore you. Drop down, give me your love, my baby, adore you. Drop down, give me your love, my baby, adore you. Drop down, give me your love, my baby, adore you. I see how you move your body, girl. I see how you move your body, girl. Olowo laye mo, that's why I'm working, girl. See my baby vibe, I make you no go away. God bless the day, baby, say you come my way. Give me love, give me dance, oh, give me life. Skibby that, make I die for your love. Give me touch, make I fall on up. Adore you. Give me love, give me that, make I dance, give me love. Make I feel your body, give me love. Give me that, make I dance, give me love. Adore you. Down, give me your love, my baby, adore you. Drop down, give me your love, my baby, adore you. Drop down, give me your love, my baby, adore you. Drop down, give me your love, my baby, adore you. Sheesh. Living Melly on the beat. Yeah. Wake them up. DJ Boat. Kobe Joe.
Gavin Newsom planning to say the Constitution by trolling the Supreme Court is what I want to motherfucker bring to your attention. And yes, this came out some weeks ago. However, it has some relevancy, right? A new California gun law, he believes, should force the Supreme Court to confront the enormity of its worst decision in decades, which they're referring to the overturn of Roe v. Wade, right? And the reason why I bring this to you is because of this right here, where you see is that the anti-abortion law that was passed in Texas, which U.S. Supreme Courts are overlooking, this law uses private lawsuits to target abortion providers. Now, I thought this was very important because a lot of people, they get in these private spaces, right? These spaces, these platforms that are privately owned, they're privately operated, you know what I'm saying? And then they start chanting their Bill of Rights. Well, I have the right to freedom of speech. I have gun rights. I have motherfreaking rights from unlawful searches and seizures and such. And they overlook the fact that constitutional rights, the Constitution only obliges the government to adhere to those motherfreaking, you know what I'm saying, those rights. So in a private space, you can't sit here and talk about you're enforced to respect my First Amendment, my Second Amendment, or whatever amendment you are feeling at the time, right? You don't have that, because at the end of the day, they're not obliged by the Constitution to uphold nothing, because of what? It's privately owned. Now, you got a lot of people ignorantly thinking like privatization is the way to go, whether it's with our education, whether it's with our prison system. And they overlook the fact that the rights that we have as citizens, these things does not apply in privately owned institutions. So when you motherfreaking have loved ones, family members, yourself is incarcerated in a prison, a jail, or a motherfreaking prison, you know what I'm saying? And you feel that your rights are being violated, you being unlawfully searched and seized, you being beat on, mistreated, you feel that you should have nutritious food, adequate, access to exercise and health and all this other stuff and medical treatment and such. And the truth of the matter is, when it comes to privately owned institutions, they are not obliged by the Constitution to ensure that none of your rights are followed. Why? Because the loophole is private. The Constitution makes no reference of privately owned structures. And because we are a nation that tries to adhere by tradition, it may never include private, the private space. And so that's why I felt that this is important, because now you have the government piggybacking off of private institutions, privatization, to inflict harm onto its citizens through its legislation, and they're evading being held accountable, responsibility, because of what? The loophole is funneling it through a private space. There's no attachment to the government, so you can't hold anyone accountable. So we're going to get into this, right? California's Governor Gavin Newsom signed a law on Friday modeled after Texas anti-abortion law, SB 8. The Texas law, which uses private lawsuits to target abortion providers. But there's one important difference between the two state laws. California's new law sends these litigious bounty hunters against gun dealers. So what California's governor, Gavin Newsom, decided to do, he said, you know what? If Texas can include this private institution, this private lawsuit targeting abortion providers, well, I could do the same thing with guns. I'm going to use private lawsuits to target these motherfreaking gun manufacturers and, and such, and producers. And so that's what he's doing. He's coming after gun dealers who sell certain guns, including assault weapons and weapons with no serial number. Now, if you are those people that like to look at this nation through bipartisan lens, even though we are a multi-partisan country, right, nation, if you like to look at it through these bipartisan lens, then there's Republican and Democrat, right? So Republicans is all like, yeah, we got rid of abortions on average. Yeah, we got rid of abortions. Good on us. Now the Democrat side, the liberal side, is saying, well, you want to get rid of abortions? Well, let's get rid of your guns using your same tactics. With the hopes of getting the U.S. Supreme Court involved, right? And so there you have it, man. We got to keep on going, though. So, like we said, this includes them selling certain guns, which are includes assault weapons and weapons with no serial numbers. Those are illegal in most states, especially here in New York. It's a high-stake gambit that will test whether the Supreme Court actually meant what it said in the Whole Woman's Health v. Jackson 2021, which held that because of SB 8's unique style of enforcement, that it was immune from meaningful judicial review and thus would take effect despite very strong arguments that the law was unconstitutional at the time. So basically what this is saying is that he's up for, it's a toss-up. However, it may rule in his favor because of the fact that the U.S. Supreme Court held that because of SB 8's unique style of enforcement, which uses bounty hunters through the use of private lawsuits to target abortion providers, it's immune from the Supreme Court overlooking this case in its for constitutionality, because they're saying none of these people are government, bodies like bounty hunters. This is a privately hired, dang near police officer, but it's a private, it's a privately hired hunter that goes out and they target motherfucking abortion providers through private lawsuits. It has nothing to do with the Constitution to the U.S. Supreme Court, and it has nothing to do with the government. So they're saying we can't touch this. We can't review this because it's immune from it, right? So shortly after Jackson was decided last December, Newsom announced that he disagrees with the Supreme Court's conclusion that states can dodge judicial review of unconstitutional laws. But Newsom also said that if the court's Republican appointed majority would give this power to states, then he would use it to limit the access to firearms. So he's saying that he disagrees with the decision made by the judges. He feels that they are, that states are not immune to judicial review, which is the Supreme Court overlooking the matters into whether or not these laws are unconstitutional. He disagrees with that. But since they want to say that it's immune, he's going to utilize the same motherfreaking structure, my motherfreaking camera went out again. But he's going to utilize these same tactics to limit the access to firearms, because he said, you want to do it with abortions? Well, we're going to do it with firearms. Easy trade-off, if you look at this through a bipartisan, perspective. So then it says, indeed, California's new gun law, known as SB 1327, is explicit that the new law's fate is tied to SB 8's. So that means that if SB 1327 get turned down by the Supreme Court, then SB 8 is getting turned down by the Supreme Court because it's structured dang near identical to SB 8. They're using the same tactics. SB 1327 provides that its SB 8-like provisions shall become inoperative if SB 8 is struck down in its entirety by a final decision of the United States Supreme Court or Texas Supreme Court. The state of California, in other words, appears to be trolling the Supreme Court. SB 1327 should force the justices to either overrule Jackson and admit that they were wrong to let states evade the Constitution, or give California's new gun ban the same immunity from judicial scrutiny that 5 justices gave SB 8, right? So that's just a long way of saying what I just told you. That is, of course, assuming that this increasingly political Supreme Court cares about consistency, which is true. They can rule against SB 1327 and still say, when it comes to SB 8, Texas's law with abortions, it's immune from judicial review, where the firearms law in California is not. Even though they're structured exactly the same, however, it will show the flaw within the Supreme Court. So honestly, it doesn't matter what direction they goes, we will see that even though when it comes to these judges, when it comes to the courts, there's a sense of finality with their decisions and such. And once they say something is pretty much set in stone, we're going to start to see the court systems unravel. It's falling apart, man. It's falling apart. Just like it'll fall apart if everyone that motherfreaking take pleas, guilty pleas, take plea bargains, motherfreaking, in fact, took their case to trial, because over 90% of court cases are resolved by plea bargains. Less than 10% of them actually goes to trial. So that means if you had 2,000 cases that goes before a court courts, multiple judges a year, right? 90% of 2,000 cases, that's about 1,800 court cases that people are just waiving their rights to trial, waiving their rights to face their accuser, the whole shebang, waiving all their rights and doing the jobs of the prosecutor, the public defender, the judge, the jury, and everyone, and just making their jobs easier and say, you know what, I plead guilty. Even though they didn't do it, they could have not done it. They take that guilty plea, and then they make that prosecutor look amazing because now their conviction rates go up. And when they decide to transition into politics, they could be like, look at me. I'm tough on crime. Look at my conviction rate. Even though over 90% of it came from people doing my job and pleading out, taking guilty pleas, instead of me actually doing my job and proving beyond a reasonable doubt that they did what I accused them of. Because, well, it's easier to dump pleas on them, plea bargains, because at the end of the day, it helps this assembly line that we have set up in the court system, right? We don't have enough prosecutors and judges and court actors and such. We don't have enough, people, and we don't have enough funding. So if everyone was to take their court cases to trial, you have a right to a speedy trial. Already, people trials be dragging out over years. Imagine if everybody was taking their junk to trial. Your trial won't be set for 10 years or so. The system, for what we know, will fall apart. Plea bargains benefit the courts. It don't benefit you, the defendant. I just wanted to throw that in there. Let's see how much left we. Okay, it's not nothing. I read this when this first came out, so forgive me. Whole Woman's Health v. Jackson is an attack on every constitutional right. So this is pertaining to the gun, right? And its structure being similar to the law surrounding abortions. But now we are getting into the motherfreaking women's health, right? So it says, to understand why Jackson is such a troubling decision, it helps to understand some of the details of how SB 8 and now SB 1327 operate. As a general rule, someone who wants to challenge an unconstitutional state law in federal court may not sue the state itself. Instead, under Ex parte Young 1908, they must sue the specific state official charged with enforcing the state law. So, for example, if a state passes a law requiring the state police to blockade abortion clinics, a plaintiff might sue the chief of the state police to seek an injunction prohibiting the state's police force from enforcing that law. So it means you can't sue the entire state for the state police's action, but you can single it down to maybe the chief of police, the chief of state police. You have to zoom it in, focus on one person with these lawsuits. SB 8 effectively bans abortions after the 6th week of pregnancy, a ban that at the same time the law was enacted violated the Supreme Court's now overruled decision in Planned Parenthood v. Casey 1992. The law also provides that this ban shall be enforced exclusively through private civil actions that can be filed by anyone who is not a state employee. So the idea is that since no state employee enforces the law, no one could be sued to block it. SB 1327 contains similar language providing for private enforcement. So I'm pretty sure that's self-explanatory to you, but it's just saying that in this ban, the only way that this can be enforced is through private civil action. So it's taking them to court and suing them for money, right? The thing is that these private civil actions literally could be filed by anyone as long as they're not a state employee. So that means in Texas, I don't know how many people live in Texas, the total population, but you take away state employees, government employees, you have at least millions of people that are capable of suing these abortion clinics, even at one time, because there's no limits. We're getting into that now, though. So the idea, like they said, since no state employee enforces the law because it's through private civil actions, you can't sue a state employee. So you can block it. So the abortion provider who is successfully sued under SB 8 must pay the plaintiff a bounty at least $10,000, and there is no upper limit on this bounty. So you could pay from at least $10,000 to upwards of billions. And there is no upper limit on this bounty. Similarly, SB 1327 provides for statutory damages in an amount of not less than $10,000. So structured exactly the same. SB 13 27 with the gun limitation is aligned to SB 8, this abortion limitation. In Jackson, the Supreme Court blessed this method of getting around the Constitution. Under Jackson, a law which is enforced solely by private lawsuits cannot be challenged in federal court. Instead, anyone accused of violating the law must wait until they are sued by a bounty hunter and then argue that the law is unconstitutional in state court. You see? So it's making it muddy and messy. The government allowed this, passed this legislation, but then they avoid accountability and responsibility. But this is not an adequate remedy against SB 8 style law for two reasons. One is that literally any person who is not an employee of Texas may seek a bounty under SB 8. So an abortion provider could potentially be hit with thousands of lawsuits seeking such bounties. Additionally, because there is no limit on the amount of the bounty, an SB 8 defendant who does not defend against every single lawsuit filed against them could be ordered to pay a bounty of millions of dollars or billions of dollars, or whatever amount is enough to bankrupt the provider. You see? And yet, state officials avoid any motherfreaking responsibility or accountability. Says SB 8 does provide that only one plaintiff may collect a bounty from an abortion provider for each alleged violation of the law. But again, the penalty for even a single violation is potentially unlimited. In effect, this means that someone bombarded with SB 8 lawsuits has only two choices. You hire an army of lawyers at an enormous cost to defend against the barrage of lawsuits, or consent to paying that bounty, which could be even more expensive than paying for the legal fees. Nothing in Jackson, moreover, prevents states from enacting SB 8 style laws that targets literally any unconstitutional right. A state could theoretically pass a law sending bounty hunters against anyone who criticizes the state's governors or against any black child who attends a majority white public school. You see, no accountability, no responsibility. Or it could be, as California has done, enact a law banning certain firearms that many members of the Supreme Court believe are protected by the Second Amendment. So this is why they're saying he's trolling, because he's like, oh, you want to do this with abortions? You want to let it slide? You know, say that they're immune from judicial review? Okay, cool. I'm going to do the same thing with guns, because I know you Supreme Court judges, y'all love your guns. So I'm going to target guns with this same structure and see if you say it's immune from judicial review. So SB 1327 enables the Supreme Court to correct its error in Jackson. It's hard to exaggerate just how much of a threat Whole Woman's Health v. Jackson is to the U.S. constitutional order. If states can evade constitutional rights through SB 8's Rube Goldberg-esque enforcement mechanism, then those rights cease to function in any meaningful way. Jackson effectively returns the nation to its pre-Civil War state, when states were free to violate the Bill of Rights at will. Y'all heard it there. We're pre-Civil War, where states were free to violate the Citizens' Bill of Rights, which is our constitutional rights. At oral arguments in Jackson, two justices who eventually joined the Jackson majority, Brett Kavanaugh and Amy Coney Barrett, seemed bothered by the idea of SB 8 style laws neutralizing constitutional rights that conservatives actually care about. Interesting. Kavanaugh even pointed to an amicus brief, filed by the Firearms Policy Coalition, which argued that if SB 8 survives, it will undoubtedly serve as a model for deterring and suppressing the exercise of numerous constitutional rights, including the Second Amendment, which is exactly what Newsom's plan was. That's why he's trolling our U.S. Supreme Court judges. Nevertheless, Kavanaugh and Barrett's anti-abortion sentiments appear to have prevailed over their desire to live in a country where state governments are required to respect constitutional rights. Both joined the Jackson majority opinion in its entirety. Now, however, the court's anti-abortion majority does not need to fear that a decision striking down SB 8 style laws will lead to a flowering of abortion rights. The court decision in Dobbs v. Jackson's Women's Health Organization 2022 overruled Roe v. Wade. States are now free to ban abortions the old-fashioned way through laws that are enforced by police, prosecutors, and other states' officials. There is, in other words, no good reason for Jackson to remain good law, even from the perspective of the anti-abortion movement, unless, of course, a majority of the justices want states to have the power to ignore the Constitution. I mean, that's, you see it. You see it. So there you have it. I think it's a clever idea that California's Governor Newsom is, putting forth with coming after, rights that conservative leaders hold near to themselves, because it's like, okay, if you want to say that this lacks, the ability for judicial review, this is immune for judicial review. Okay, so when I come for you, the things that you enjoy, the rights that you like, let's see if you say that same thing. Because like I said, either way, if they decide like, yeah, we're not going to keep true to this, these laws are not immune to judicial review, and they overturn it, they show error on their parts. If they do not decide that, okay, we still want to keep anti-abortions, but we come in for the gun laws, then they show that you're picking and choosing. Like, there's still flaws in that because of the fact that it's these two different laws that are structured identically, but they're going after two different things. You see what I'm saying? If you choose one for the other, you look crazy. You look crazy as a Supreme Court judge. You know what I'm saying? Because now it's like, bro, what you doing? So, I mean, without further ado, I'm out of here, y'all. I hope y'all learned something from this motherfreaking, this video. Stay prayed up. Love your neighbor as you love yourself. Don't put no other God before the great Jehovah. And always remember, you can't get to Jesus you can't get to the Father unless you go through Jesus. Peace. If you want people to think otherwise of you more positively, then give them more positive experiences.